Hey, what's up, guys? So I just came out with a video in which I discuss 5 out of the 6 crimes that Kyle Rittenhouse was charged with. In today's inquiry, we are going to discuss the 6th charge as to whether or not it was legal for Kyle to possess the rifle that he had. If you haven't already, subscribe to this channel. You are watching Inspiring Inquiry. Since the shooting that took place in Kenosha, Wisconsin, in which 2 people lost their lives and a third was injured following the police shooting of Jacob Blake, a lot of information has come out about the shooter and the victims, and a lot of misinformation has come out about the shooter and the victims. We're going to address some of that in today's video by talking about whether or not it was legal for Kyle to have the rifle that he had, that he ended up shooting and killing some of the protesters / rioters in Kenosha, Wisconsin. There have been a lot of questions that have been raised that I think are definitely warranted as to whether or not Kyle had the intentions of taking anyone's life when he went there that night. But regardless of those intentions, whether they were noble or not, in today's video I wanted to focus on the legality of him having that rifle. A number of people came out saying that it was illegal for Kyle, a 17-year-old, to cross state lines with a weapon and go to a protest outside of his own state and end up shooting and killing some of the protesters. Now, he has claimed that he was there defending businesses, and a lot of people have said that he shouldn't have been there in the first place. Well, given this statement put out by the Kenosha County Sheriff's Department on August 25th, no one should have been there, but at least the people raising this concern are truthful in saying that Kyle himself should not have been there, especially being 17 years old. But what about the claim about him crossing state lines with a weapon that he legally wasn't allowed to own? Well, let's go ahead and turn to the person who is claiming to be one of the attorneys of Kyle Rittenhouse, who took to Twitter to respond to some of these claims, one of them being, "So the first guy who was shot in the face was actually a result of Kyle shooting into the crowd. Afterwards, he still was carrying an illegal gun in a different state. That self-defense doesn't come into play since it was illegal to begin with." Lynn Wood, the attorney, responding with, "When you start manufacturing facts to support false accusations, you get into trouble under the law of defamation. Kyle did not carry a gun across state lines. The gun belonged to his friend, a Wisconsin resident. The gun never left the state of Wisconsin." So according to Lynn Wood, Kyle, the 17-year-old, did not cross state lines with an illegal firearm. But let's not only take his word for it, let's go ahead and look at a news article I was reading in which it reported on what the police said about the firearms they collected from Kyle Rittenhouse and another unknown person. According to ABC7Chicago.com, they write, "The I-Team has learned from federal investigators that the gun was legally purchased. However, authorities are still working to figure out how it ended up in the teen's hands. A few hours later, when Rittenhouse voluntarily surrendered to Antioch police, quote, our department did take possession of 2 Smith & Wesson M&P 15 rifles. The ABC-7 I-Team was told Thursday by Police Chief Jeff Gutzchow, quote, these rifles were subsequently turned over to Kenosha Police Department in furtherance of their investigation into the shootings that took place there, Chief Gutzchow said. Even as the teenager is being held in a Lake County lockup while extradition proceedings play out, investigators on both sides of the state line work to, quote, determine when, where, how, and by whom the firearms were purchased, and to determine if any crimes were committed in our jurisdiction in doing so, end quote. And we can also look to the criminal complaint itself because of the 6 crimes that he was charged with. Crossing state lines with an illegal firearm or anything akin to that wasn't one of them. The only thing that addressed the firearm was that each one of them had an addendum of use of a dangerous weapon, and the 6th charge was him possessing a weapon under the age of 18. Well, let's go ahead and address that. Was Kyle Rittenhouse in legal possession of the AR-15 style rifle? We're going to take a look at the statute itself in just a moment, but before that I wanted to reference another article that I was reading in which a lawyer who specializes in these kinds of cases was speaking on the matter. Let's turn to the Milwaukee Journal to go ahead and see what he had to say. According to the Milwaukee Journal Sentinel, under a section titled "Could the Suspect Carry the Rifle Legally?" it says, under Wisconsin statutes that say anyone under 18 who, quote, goes armed, end quote, with any deadly weapon is guilty of a Class A misdemeanor. Kyle Rittenhouse, 17, was not old enough to legally carry the assault-style rifle he had. But John Monroe, a lawyer who specializes in gun rights cases, believes an exception for rifles and shotguns intended to allow people ages 16 and 17 to hunt could apply. If we go down here a little bit, we can see where Tom Grieve, a Milwaukee defense lawyer who also specializes in gun cases, agreed the exception might apply beyond hunting, but said that part of the law is poorly drafted. He said he would argue to apply a rule of law that interprets ambiguous criminal statutes in favor of the defendant. He goes on to discuss some other things that may have made it illegal, but given the current situation and what we understand about the events that took place, there isn't any reason to believe that these things would actually apply to this situation. Now that we've heard from experts in this field, one saying that it is for those who are 16 and 17 years old to be able to go hunting, and the other one that says that it was poorly drafted and that is left ambiguous, and so it's going to be up to someone else to interpret whether or not it was legal for him to have it. Let's go ahead and turn to the statute itself so we can look at the wording and see whether or not we can discern if it was legal for him to have the rifle. According to Wisconsin state law, under section 948.60, possession of a dangerous weapon by a person under the age of 18. In this statute, section 1 goes on to describe what a dangerous weapon is, but given the fact that we know that this is already classified as a dangerous weapon, let's go ahead and skip to the second part, where it states any person under the age of 18 years old who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. Now, sections B and C don't concern Kyle, but rather the person who gave him the gun, and section D is addressing those who are under the age of 17, which Kyle is not. He is over 17, so neither of those three apply to him. But if we go down here to section 3, we can look at A, and it also says this section does not apply to a person under 18 years of age who possesses or is armed with a dangerous weapon when the dangerous weapon is being used in target practice or under the supervision of an adult in the course of instruction. Well, we know he wasn't down there for target practice, tongue-in-cheek jokes aside. He wasn't down there for target practice. Section B also talks about whether or not he's with armed forces or the National Guard, which he is not, so that also does not apply to him. But section C is what they are referring to when they're saying that he either was or wasn't allowed to have the rifle. Let's read it and see how it reflects on the rest of the statute. Under section C, it says this section applies only to a person 18 years of age who possesses or is armed with a rifle or a shotgun if that person is in violation of section 941.28 or is not in compliance with subsection 29.304 and 29.593. This section only applies to an adult who transfers a firearm to a person under 18 years of age if the person under 18 years of age is not in compliance with those three sections. Well, let's go ahead and take a look at what those three sections are to see whether or not he's in compliance with them or whether or not they have any bearing on this situation whatsoever. Section 941.28 addresses possession of a short-barreled shotgun or short-barreled rifle. Let's go ahead and save some time. He didn't have a shotgun and he didn't have a short-barrel rifle. The rifle has to meet a criteria of being less than 16 inches measured from close breech to the bolt face to muzzle, or a rifle having an overall length of less than 26 inches. Now, I'm not a gun expert, but I have been told and read that that gun wasn't shortened in any way and that it met those requirements. So this section doesn't apply to the statute. The next section that would disqualify him is 29.304, restrictions on hunting and use of firearms by a person under the age of 16 years. Now, he wasn't under 16, he was over 17, so this section also does not apply to him. Lastly, section 29.593, requirement for certificate of accomplishment to obtain hunting approval. So let's go ahead and go back to the statute to see how this affects whether or not he was allowed to have the gun. Again, it says this section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is in violation of 941, which is a short barrel, which he is not, or is not in compliance with subsection 29304, which also says that he was there hunting, or that he had the certificate on 29.593. None of those apply, so it does not disqualify him from being able to have a standard long barrel rifle. Well, now that we've read the statute and we've gone over the nuance in the statute and the difference of opinion from the different lawyers, what does it come down to? Well, it all comes down to being argued in a court of law. We've talked before on other videos about how one interprets the law and the three schools of thought that are behind it. There is textualism, what does the statute actually say? There is intentionalism, what was the purpose of the statute when it was enacted? And lastly, pragmatism. If you rule on this case in a particular way, what kind of effects is that going to have going forward on the future, on other people in this situation? Well, we have the first lawyer that we heard of, who is an intentionalist, who argues that the intent of the statute was for hunting purposes and that it doesn't apply to Kyle Rittenhouse. The other lawyer argues for textualism. He says, according to the words of the statute, that Kyle is definitely legal to have that firearm. Well, personally, I think that the judge should make a pragmatic ruling on this particular statute. What is this going to mean going forward? Should he rule on it that Kyle was perfectly legal to have that gun, or should he rule on it and clarify that it is for hunting purposes only? That is a decision that the judge is going to have to make on his own, and I can't make it for him. I can only say what the law says and say what the different schools of interpretation are when it comes to this law. So, was Kyle Rittenhouse legally allowed to have the firearm that he had? Open to interpretation, and we're going to have to see that in a court of law. Well, guys, as always, I appreciate you watching my video. If you haven't already liked this video, share this video so other people can be informed on the nuance of it as well. Subscribe to this channel and make sure to hit the notification bell so you can be informed when all of my new videos come out. If you want to, please leave a comment on this, whether you want to argue with me, whether you want to agree with me. Any and all thoughts, you can share them down below. As always, you guys are watching Inspiring Inquiry.